Welcome everyone to our webinar on attracting and retaining top talent, legal strategies for small businesses. I'm James True. I'm a practice group leader here in LegalVision's employment team. And my co-host today is Emma Bucholtz. She's a lawyer in our team. Now, before we begin, just a few quick housekeeping items. You'll receive a copy of the recording and the slides in your email afterwards. Throughout, feel free to submit your questions in the chat box, and we will answer as many of them as we can at the end. And then finally, we do ask that you just complete the feedback survey. We do a lot of these webinars. We want to make them as useful and as helpful for you. So we really do welcome all the feedback we can get, so we can just improve them continuously. So also just to note, for the next 48 hours, you're eligible for a free consultation with us. And that's how we can basically discuss how we can help your business. Just leave your contact details in the survey at the end of the webinar. In terms of what we will be discussing today, nailing the hiring process, legal risks when you're hiring. We'll talk about individual terms of employment, short-term incentives, long-term incentives, and then business-wide, maybe additional incentives you might run in your organization. Finally, tying all of that into some sort of critical legal aspects of culture within your business. And as I said, we'll also try and get to any of your questions that you submit throughout. So I'll kick us off. Firstly, we'll be talking about just nailing the hiring process. Now, one of the key aspects to hiring talent is having a really well-run hiring process. It's the first impression of your business to a new candidate and an opportunity for you to show that your business is a well-run outfit. This can be a real challenge for many startups or small to medium businesses. They'll commonly start with maybe one or a handful of people wearing several or many different hats. To scope out, secure, maintain your early clients. You're trying to get suppliers. You're trying to manage a business compliance generally. You're trying to grow the business, and you might have the same person also trying to handle your HR function. So there's a lot to do, and trying to make sure you're giving attention to your hiring process can be difficult, but it's critical to making sure you get the right people. So managing those competing responsibilities, yes, it's stressful, yes, it's tolling, but again, it's something that you need to have nailed down so you can bring on and trust that new hire. You want to set yourself up for success when you're recruiting, and doing the groundwork early is going to minimize any risks with hiring. One of the first things to think about is actually when is the right time to hire. So as a first step, before developing and advertising a role, you want to assess your current capabilities and resourcing, basically to assess, okay, is it actually the right time to be bringing someone on? You need to ask yourself questions like, do we need a specific talent to fulfill the role? Or is it possible that the duties which we need perform, is it possible for them to be assumed by other staff? Can we do a little restructure here and cover what we need? Do we have the resources to train a new hire? Is there actually someone available to take on that managerial or trainer responsibility, if that's going to be a requirement for that role? Some other things, sometimes obvious, but critical to think about is, do we have the cash flow to maintain the role on an ongoing basis? Or do we need to be only committing to a fixed period? Have a think about what that salary is like at the point of hiring, but also what are the expectations? Does the future employee have expectations that that salary is going to increase? Things you need to think about at the start so they're not problems for you later. You can also consider whether there are processes or technology you can use to improve your efficiencies. That will also, once you've considered that, allows you to reassess the need for hiring. Think about upfront costs. Are we going to spend on not just the salary, but recruitment, training, equipment? Do we need to find some money for sign-on bonuses or things like that? And I think also important to know Are we ready? Are we educated on our legal obligations to employees? Are we actually ready to employ someone? Can we ensure compliance with workplace laws? That's employment side of things, as well as maybe safety side of things, which are very critical if you're going to bring someone on. There's a lot to think about before you've actually then started the process. But that's your next step, is making the actual process with this candidate as good as it can be. So what are some practical steps for an efficient or an impressive hiring process? Well, you can maximize the chances of attracting your ideal candidate by basically just having a really quality hiring experience. So number one, have a plan, know the role, know the duties, and know the market before you go and spend money on recruitment. Obviously, there are monetary and time costs associated with going out to market. Even if you're not using a recruiter, it'll still cost you resources internally. At a broad level, the hiring process, it looks like, number one, you're drafting a job ad. And the tip here is you need to know exactly what you're looking for. So you need a very clear, before you go and draft that ad, you need to know exactly what you want. You're going to post the ad, think about whether you're posting it in the right places, think about whether you want to engage a recruiter to assist with that, to expand your reach. You'll then be interviewing candidates. Do you have a clear plan here? Are we talking about a 1, 2, 3 interview process? Are you going to require them to perform any tasks so you can assess their skills? Be clear up front so the employee is aware of their process they're getting into. You don't want a situation where someone thinks they've come in for one interview and then they get asked for a second, a third. They weren't aware it was going to do that, and they feel like they're being strung along. They could lose interest in the process. Finally, you make an offer. And when you make an offer, ask yourself, have you captured everything you're putting to the employee? And commonly, this is missed. The offer goes out in very simple terms, but you want to be clear about exactly what it is your business is offering this person beyond maybe the salary, which is usually the critical thing which you have communicated. And we're going to talk about all other things that you can be putting to an employee to make it a more attractive offer. Make sure all of that's there. So with all of that in mind, yes, you definitely need to give a lot of thought to each of those aspects. And you want to make sure that then when you're moving forward in a way that's not going to create legal exposure for the business. And here I'll hand over to Emma. Perhaps maybe just talk us through some of the common legal risks that a business might encounter when they're hiring.
Thanks, James. So at every stage of the recruitment process, you will have legal obligations as an employer and even as a prospective employer, so even before you bring these people on board. Now, you may be exposed to claims under anti-discrimination legislation, potentially workplace laws like the Fair Work Act, or consumer protection laws, and this can include penalties for non-compliance. Now, beyond the obvious legal risks here, not getting this right in the first instance might send the wrong message to your potential hires about your business. So we really want to be painting a picture of a compliant business and a great business to be working for. Now, the first thing to be aware of is discrimination risks. Really broadly, under federal and state anti-discrimination laws, there is a prohibition against discrimination in relation to advertising and the offering of employment. Now, you should avoid using language in job advertisements which could discourage persons with protected attributes from applying for that role, or imply that only persons with a particular attribute will be considered. Now, there is an exception to this, and that is where the actual requirement is an inherent requirement of the role. Now, this is a little bit nuanced. It's not always straightforward, so it might be something you want to seek advice on if you are considering putting something that may potentially be discriminatory into a job ad. Just to run through an example, a job advertisement promoting a young and dynamic team is something that you may often see. It's not uncommon for employers to put something like this in a job ad to, I guess, encourage younger people to apply or to promote the idea that the business is one that's up and coming and exciting to work for. Now, this could still expose you as an employer to a complaint of discrimination under the Age Discrimination Act, by giving the impression that the role is restricted to candidates of a particular age. You should also avoid asking any discriminatory questions during an interview process with your potential candidates, unless, again, that is to determine their ability to perform the inherent requirements of that role. So questions like, do you have children? Do you intend to have children? What's your religion? Those sort of questions should not be asked, as they more assess personal characteristics rather than somebody's suitability on an objective basis for the role that you're hiring for. So a takeaway there is to always be objective and consistent across the board and focus more so on skills and competencies in your interview questions and your job advertisements. Now, whilst these things do relate to compliance and mitigating risk generally for your business, being asked personal and unnecessary questions might be uncomfortable for potential hires, could also be a red flag for the candidate, and can operate to actually cause some reputational risk for your business as well, which might have flow-on effects for your future hiring prospects too. Now, something else just to be very conscious of is misleading job advertisements and misleading behaviour when making offers to your employees or prospective employees. Now, job advertisements may also fall foul of the Australian consumer law and result in significant financial penalties for your business if they're misleading or deceptive. An advertisement might mislead a job applicant under Section 31 of the Australian Consumer Law, or the case law generally, in a number of ways. And this can be in relation to the identity of you as an employer, the availability of the work within your business, the nature of the work involved, the conditions of employment specifically for that individual. So that could be things like the remuneration or any bonus packages, for example, as well as the financial standing or profitability of the business generally. So that can obviously flow into conversations around where the employer is headed, the success, and also the future prospects of that individual within your business. So it is really broad, and it's really important that you are conscious of all of these factors. To that end, there can also be risks in omitting particular features or details about a position to entice a candidate to join and to accept a job offer. Now, it is also unlawful under the Fair Work Act to advertise a rate of pay in a job ad that would contravene the Fair Work Act or an instrument like a modern award. Now, of course, we'd hope that you are paying at least the national minimum wage or award minimum wages to your employees once you are bringing them on board. That is a separate issue under the Fair Work Act, but just really need to be aware that actually advertising roles that fall below that will also put you in foul of the law as well. So to that end, when considering all of these risks, we do recommend that before you post a job ad or make an offer of employment to a prospective employee, you inform that person of the role and the benefits. And also you consider whether your conversations you're having with those individuals will fall foul of the law, whilst also balancing that alongside trying to attract the talent. So often it's, we want to make sure that they are feeling comfortable taking the leap from their previous employer to join you, but we don't want to be overstating the business's position or over-promising to them in a way that will cause issues down the line. So, of course, if you have concerns that your job offer or an ad that you have put together may not be painting the entire picture for a candidate, you should seek some legal advice. Lawyers like James and myself, we can have a look over that for you. We can advise on any potential risk exposure for you, and maybe just point you in the right direction around your drafting, and to ensure that you are taking proactive steps to comply with your obligations at law. Now, this does move nicely into a discussion about the specific or personal terms of employment for the people that you are bringing on board to your business. So ordinarily, once you have selected the successful candidate, you should make a verbal job offer to them. And this should ensure, of course, that it's truthful and that there's nothing misleading in that verbal offer. And we do also recommend, as James flagged earlier in our discussion, that this is swiftly followed up with actually a formal offer letter and formal terms of employment, so an employment contract. Now, once you're making this offer, you might find that the successful candidate wants to actually use this opportunity to negotiate aspects of their job offer. And it's not uncommon for that to happen at this stage, and particularly for more experienced or senior talent who are taking a significant leap or risk when leaving their former employer to join you. So you should carefully consider your capacity to actually engage in these negotiations and be very conscious of your upper limits and commercial needs once doing so. Of course, we want to balance getting the best talent alongside not putting ourselves in a position where we can't actually afford to keep them on long term. Now, once you and the successful candidate have actually landed on an agreement, and that might be part of the package, it might be part of additional benefits that you're affording them as well, like a car or a fuel card, for example, these terms should be carefully considered and drafted in an employment contract. Whilst it's not an obligation at law to have a contract, it will operate to protect your business at the highest level. And of course, we'll make the terms really clear for all the parties throughout the tenure of the employee. Now, beyond actually including the remuneration and associated benefits in that contract, we also recommend that your contracts include other standard protections, and this might be really, really relevant for senior employees and top talent you're bringing on as well. Now, specifically, things like confidentiality, intellectual property, and a notice period is what you might want to consider including in that employment contract. The issue of notice is very interesting. I think we often get questions around what's reasonable for my employees, what should I be thinking about when including this in the employment contract? We would say that ordinarily senior employees are more commonly tied to higher notice periods or longer notice periods. Sometimes we see this in excess of, say, 4 weeks up to 3 months. That's not a hard and fast rule, but you should be considering, turnaround. You should be considering whether that would facilitate an ease in transfer of work if that person finishes up with you, and maybe even thinking about the protection of your assets and your client relationships when having them perform work during their notice period. Sometimes we can sideline them for that time, so something to think about for your more senior workers as well. Now, that does tie into a question on restraints of trade as well, and this is a term that we commonly include in employment contracts, at the very least, just to deter people from competing with your business or soliciting or enticing your employees, clients, and suppliers. Now, the position at law is that restraints are unenforceable at first instance as a matter of public policy. In short, the courts don't want to stop people from being able to find work, but of course, this needs to be balanced alongside protecting your interests. And in many cases, it makes more sense to have them in there than to not. But we do see some talent push back on these as well, just to, I guess, general knowledge that they aren't enforceable. So something to be thinking about. Now, once we have got an employment contract in place that really defines the individual terms of employment, you might also want to start thinking about introducing some short-term incentives for your workers. Now, whilst nailing the hiring process and paying a competitive salary may attract top talent to your business, these short-term incentives, and this will also lead on to a nice conversation with James about long-term incentives and business-wide ones as well, but these will ensure to keep your talent engaged during the tenure of their employment. It might also assist in the business just actually reaching individual and team-wide goals as well. So your short-term incentives can be structured to encourage strong performance and outcomes for your business, and they can also align the employee's short-term goals with the business's goals. Now, beyond these obvious benefits, recording and rewarding performance does send a message to your workers that your business values outcomes. It also builds trust in your team and can support personal development within each individual's career as well. Beyond that, you might stand out as an employer of choice. People talk. So, if people are telling others, oh, there's a great scheme within my employer's business, they really, really do recognize high performance, and it's very clear that this is really equitable. That puts you in a good position to go to market in the future as well. Now, we would say as lawyers, one of the most recognizable incentive programs we see our clients carry out is a commission-based program. So this might be a situation where your salespeople are encouraged to generate specific revenue or hit specific KPIs. And you do that by offering them a percentage or a specific amount on the value of monthly gross sales, for example. That's just one example. They can take many forms, and one of those forms could be potentially a bonus structure. Now, we do see that in the form of a retention bonus when you're bringing on talent. That might entice them to come over and take that risk to start with your business. We often see that this can be, I guess, a profit share scheme, for example, where we look at the total profits of the business throughout the whole financial year, and we distribute those profits amongst the team, maybe based on individual output or potentially even based on the actual issue of specific units at the commencement of employment. That's something we do see as well. Really important to think about this on, I guess, an industry basis as well. What works for one business might not work for the other. So it is really important to seek advice on what makes the most sense and really be thinking about your company's performance or your business's performance generally before committing to these sort of schemes as well. Now, just to speak a little bit to the actual content and form of those short-term incentives, we think that they should consist of 3 key elements. And this should be, number one, some sort of KPI that actually has metrics, to measure performance or output. So they should be really clear. There should also be targets that are measurable, objective, and motivating. So the key here is that they're not impossible, they are reachable, but they're not so reachable that everyone in your business, no matter how strong a performer they are or how weak they are as a performer, will actually achieve them. And of course, the main consideration is the reward component. So we think that this reward should be proportionate to the individual's added value. You could think of this in its truest form as a cash reward. We could also consider non-cash rewards, so social outings or other gifts that you're providing. But of course, we should just consider the tax implications with any of these payments as well. Your accountant can probably help you with that, or alternatively, our tax team may be able to provide some advice too. To that end, just around actually providing the incentive schemes to your workers, we do recommend that these sit outside the actual written terms of employment, so the employment contract. You might sometimes see that they sit inside the contract to get people across the line and signing those agreements, but that does tie your business to obligations to actually pay out those amounts. So where they sit outside the contract, you do retain some level of discretion, and you do have the ability to actually vary those terms of the scheme as necessary. But of course, that should be balanced alongside not misleading your talent or undercutting them in the payment of those short-term incentives as well. Now, just to tie in the last couple of tips here for an incentive program. So we've talked a little bit about form, but we do think that there are some key tips that you can take away out of today. Now, a great incentive plan should be understandable. There should be a very clear purpose. Your KPI should be clear, as we discussed. The effort required to meet the target should also be clear. Now, it should also be equitable, and equal performance should be rewarded equally. Now, unfair or inequitable schemes across teams or individuals can be demotivating for your individuals. They can also be unethical. You certainly don't want to be falling short of discrimination laws either in carrying these out. They should also be proximate. So there should be a logical link between participation and rewards. Last two should be actionable, as we discussed, so not impossible, achievable, balanced nicely with performance as well. And they should be simple. It should be easy to track, easy to actually implement within your business as well. So we don't want them to be a huge administrative burden for you either. So keeping all of these things in mind, we do recommend that you, of course, seek advice when building these out. We can talk to you about what makes sense for your industry. James and I have a lot of experience speaking with clients of all sizes and in all industries, so can certainly guide you there. Now I will hand back to James just to talk us through the long-term incentives and business-wide incentives that you can consider implementing as well to retain your talent.
Thanks, Emma. Yeah, look, a lot of those things that Emma's just mentioned there will apply when we're talking about long-term incentives as well, in terms of being clear, being accurate, making sure we've got actionable items and all the rest. So that all certainly applies when it comes to a long-term incentive. One of the most common long-term incentives is an ESOP, so an employee share option plan, and then there are other employment share schemes. So with an ESOP, you'll generally grant the employee options in the business, and that's an option to buy shares in time. Usually those options will vest over a period of time. And that can be, 4 years vesting is a common timeline, and they'll vest during that period. They can ultimately then be exercised by the employee once they've vested, and at that point they turn into shares. Nominally, the employee will pay a small price to then convert them into shares. Now, that will commonly happen at what's called an exit event, which is something like the sale of the business or some investment in the business. ESOPs are common long-term incentives, largely because there can be real tax benefits to employees, in that they'll typically not be taxed on all of those shares. When they do, ultimately, if they sell them at an exit event or something like that. And those tax concessions really apply in relation to startups. So definitely something worth exploring, tax advice critical if you're looking to explore an ESOP. You can also just have share schemes where you'll be, issuing shares, but the shares will vest. So the employee basically gains shares over a period of time. The benefits with share schemes and long-term share schemes are that, the employees will have some ownership of the business in an actual sense. And we do see this really drives engagement. And secondly, the plans encourage employees to stay in the business long-term. Most of these long-term plans are really geared at kind of back-ending the entitlement. So it's worthwhile for the employee to stay around to realise those benefits. You can also just operate long-term incentives in the form of just long-term bonus schemes, really. So you might choose to share percentages of company profit subject to targets or milestones being hit, or you might otherwise, set long-term individual KPIs for an employee and they get a cash bonus on completion. There's a lot you can do here. It's critical just to get the drafting right. What are we going to give you, and what do you have to do in order to be entitled to it? And then, as I mentioned earlier, get some tax advice, from a tax lawyer or maybe from your accountant, just so you understand the implications for the business and for the employee, particularly in relation to those share schemes. Now, it's not just those individual entitlements, in a sort of a cash or a salary basis that can make you an attractive employer. Those short and long-term individual incentives, they're personally negotiated. They can increase the output of your individual performers, but you can also think about business-wide incentives to attract talent. Now, that can be something you actually consider as advertising as a benefit, and we're increasingly seeing businesses do this to go beyond, say, salaries and bonuses in order to attract talent. A common one is additional annual leave. We're increasingly seeing businesses offer 5 weeks annual leave. Some businesses will offer unlimited annual leave. There are some trips and traps around that and questions as to whether it's that effective or not, but it is still something that we are seeing some businesses do. Paid parental leave is another really common, entitlement that businesses don't have to provide. There's no obligation to do paid parental leave under Australian law. There is an entitlement to unpaid parental leave under the law here. But going above that and paying employees is really another place where employers can make themselves attractive to prospective employees. Same as sick leave. So other businesses will also add in, as I mentioned, with unlimited annual leave. Some businesses are also doing unlimited sick leave. You can also think about doing things like professional development budgets, investment in continued learning, maybe tech enhancement. Think about budgets for social events, so granting your employees or their teams monthly annual budgets to organise their own social events, or otherwise just making the company, the company calendar have its own sort of team events throughout. Critical in all of this is just to remember, if you're going to introduce these types of measures, you need to implement policies to govern the entitlements. And those policies are critical, and the way that those policies are drafted is critical, just to make sure you've got really clear eligibility parameters. You don't want to get caught offering entitlements and then accidentally through your drafting offering more than you wanted to, or making it available in circumstances where it wasn't meant to be. So always think about how that is communicated and make sure you're very clear on that. But those are great things you can have beyond salaries and bonuses. I guess we've touched a lot on, all those other things that you can do to make your business an attractive offering for a candidate. And just to wrap up here before we move into questions, just want to touch base very briefly on some of the legal aspect of these kind of common cultural issues. Having a great culture is definitely going to assist in attracting talent. And very commonly that's driven by, what we call non-legal things like leadership of the business, and the culture that creates between your workers. But those aspects are still underpinned by legal aspects. So complying with workplace laws obviously needs to be a minimum driver of your business culture. But within that, you want to make sure you're maintaining workplace policies. So you want to be looking at compliance in relation to anti-discrimination, harassment and bullying, policies in relation to work health safety, even IT policies governing sort of reasonable use and people's conduct on your IT systems. You also want to be rolling out regular training for your workers, basically on what is and isn't acceptable. Now, that's important, just for your culture generally, but that underpins a lot of your legal compliance issues where employers are liable for those claims between employees, unless employers can demonstrate they've taken reasonable steps to prevent it. So policies and training is really critical for those reasonable steps. Another big development we've seen recently in the law is that, a business has WHS obligations that requires it to eliminate or minimize psychosocial hazards. Now, that expressly includes things like poor management or excessive workloads. So a legal compliance aspect is, yes, you definitely need to be taking steps there on the WHS side of things, on psychosocial hazards. But that has a real benefit because compliance with your legal obligation there is going to drive some far greater culture within your business, going to make it a more attractive place to work. Finally, I think grievances and complaint handling, well, that really sets the tone just to demonstrate how serious you are about managing compliance and promoting a strong culture. So it's one thing to have all of your policy statements about, what we say isn't acceptable in terms of employee conduct. But the businesses that we see thriving are the ones that act on their complaints and they take proactive steps to actually enforce their standards of conduct. So those policies are just more than a piece of paper in the top drawer. So having grievance and complaint handling policies as well, they can really assist a business and make sure that your individual employees, you want to make sure there's someone very clearly appointed to manage those processes so it doesn't get lost on, whose responsibility is it to actually handle that compliance side of things. All right, well, we've rolled through quite a lot there. I'm going to hand back to Emma and I'll have a look at some of the questions that have come through as well, and we'll answer those shortly.
Thanks, James. Now that concludes the main part of our webinar. You might find our How to Hire and Inspire guide useful. I know this has been drafted by James, our practice group leader in the team. So you can download that by scanning the QR code available on your screen now. And of course, can access that on our publications page on our website later down the track if you need. I will just leave that up there for a moment for you. Great. Now, you might also be interested in our upcoming event. Our next webinar will be on workplace policies, what every employer needs to know. And that ties in really nicely to the things James and I were discussing today, setting up your documents within your business to ensure compliance generally, and then just carving out, what we can do to clarify these additional benefits, for example. Now, that is occurring on the 19th of September at 11 a.m. And just as you did for today's webinar, we do ask that you register via our events page. You can find that on this slide now. Now, just finally, we will answer some of your questions shortly, but whilst you submit them, we will take a minute to tell you about our LegalVision membership. Now, by becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business as usual legal needs. So it's like having your own in-house counsel for a fraction of the cost. Now, our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, as well as much more. Now, as a LegalVision member, you won't worry about the cost of lawyers ever again. So think of it as having your own in-house counsel. We'll take care of the business as usual legal work, so you can focus on running your business. We also offer a dedicated service for in-house teams and general counsel to manage your high volume business as usual legal tasks as well. Now, our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. To learn more about our membership and how we can help you, please request a free consultation when the survey appears at the end of this webinar. Now we will answer some of your questions. I'm just having a look at some of them, and please do continue to pop them into the Q&A box as we run through them. James, I will throw to you for a couple of these questions. We've had a great one come through here. The question is, what are your views on contract lengths for senior appoints? So fixed term or permanent employment agreements?
Sure. So this is kind of an interesting issue, particularly with the senior appointments. Commonly, that might mean they're actually not protected from unfair dismissal. Why that's relevant is if you were to engage them on an open basis where they're not protected from unfair dismissal, might actually make things a little bit easier to terminate down the line. So think about what your termination right might be, how many hoops you're going to need to jump through with that person if you need to terminate their employment further down the line. So a kind of open-ended employment might actually be okay or less risky for a business there, as I said, if they're senior enough to not be protected from unfair dismissal. There are also recent amendments to the law in relation to fixed-term contracts and how you can utilise them. So at a very high level, there are just some limitations on basically using consecutive fixed-term contracts. So businesses that have, historically sort of, in a sense, protected themselves by only engaging people for short terms and then offering extensions are not really going to be able to do that anymore. Now, of course, if you've still got, the requirement to only bring someone on for a short period, that's totally fine, and nothing prevents you from, extending that engagement. But you can be prevented from extending it on further fixed-term engagement. So you might then say start with your fixed-term arrangement, and then if all things go well, you can turn it into ongoing open-ended employment. And if things don't, you can let it end with that fixed term. But commonly, this will just be a matter of negotiation. What it boils down to, whether the employee is, if they're looking for open employment and they're a good candidate and a strong candidate, then that might ultimately be your driver.
Great, thanks, James. We've had another one come through here. The question is, for a startup short of funding, should we be considering contractor agreements where we can't pay those top talent, or are there other options for engaging them?
Sure. So, it's very tricky at the early stage when you don't have any money or waiting for funding to bring people on. The reality is many businesses just run into non-compliance with the law here. If they employ people and say, we'll pay you in the future, they're technically breaching the act, and there's nothing they can do to get around that. If you do bring someone on as a contractor, and contractors, genuine contractors, aren't entitled to things like minimum wage, you can be much more flexible. So yes, in that instance there with question, could you say the fee is payable once we get funding? Yes, you can definitely do that. The thing you need to think about is whether or not that employee or that worker is a genuine contractor. So the law is changing in literally 2 weeks on this. And what we're going to have is a situation where you can't just call someone a contractor. That if they challenge it, the courts would basically look at the entirety of that relationship, work through some pretty complicated and long indicia, and make an assessment of whether they are in substance an employee or a contractor. But of course, if they do land on contractor, then you're fine. You can be really flexible about payment for contractors. You could have, very long payment terms. You could have, fees of $0, that turn into, higher amounts subject to funding or subject to other kind of, KPI performance, other sort of investment. So you have all that flexibility with a contractor, but not with an employee. If they're a genuine employee, then they're entitled at a minimum to minimum wage for every hour they work. As I said, very common for businesses just to break the law there because there's no funding in that early stage, but not much you can do around it if they are an employee.
Great, thank you. Another one has come through just around how to pick the good from the bad applications. So the question here is, when you are interviewing your applicant and they talk themselves up to a point that they would seem like the best applicant, what can you do if they turn out to not be what they promised?
Yeah, it's a great question because it's really common thing to happen, and it's very hard. People do. There can often be quite a lot of bluff in an interview. Obviously, the strength of your questions in an interview, giving a lot of thought to what questions you're going to ask, interrogating previous experience, and then really interrogating how they perform in the interview. That's sort of the first bit to make sure that your interview is actually an effective way to make an assessment of them. But of course, even with, the world's best interview questions, they can still impress you when they don't have anything to back it up. And there's not much you can do beyond that. It's really making sure that you are able to deal with it after they've started employment, and then they have turned out, you've made an assessment that they haven't turned out to be what you thought they were. And this is really critical, that your employment contract has a probationary period. Now, commonly a probationary period is going to be a 6-month period from the commencement date. And during that time, you'll be able to terminate the employment by providing just 1 week's notice. That's the minimum amount of notice an employee is entitled to at law. The important thing is, in that first 6 months, the employee will not be protected from unfair dismissal. And it's the first 12 months if you're a small business. But what that means is you can move very quickly on a termination in that first 6 months. You don't really need a valid reason to terminate, and you don't need to afford the employee procedural fairness. So at any time during that first 6 months, you say, "Oop, you're not what we thought you were, and this isn't working out." You're not required to go through a performance improvement plan. You're not required to give them 3 strikes and then they're out, or send them warning letters or anything like that. None of that stuff applies yet. And you are actually entitled at law to just pull the trigger on the termination, and the employee can't even bring an unfair dismissal claim to challenge it. They can still bring other claims, in relation to discrimination issues or victimization issues. So as long as your reason for terminating is just because they're not a poor performer, and say not linked to anything like, their age, race, religion, or them having exercised any of their workplace rights, you can terminate very comfortably, knowing that there's not going to be an exposure for the business. So make sure you're basically primed to deal with it after employment, and act on those probationary periods. Too many businesses, come to us with an employee who's been there for 7 months, and they've forgotten that the probationary period had passed. And suddenly we've got a big headache trying to get rid of that employee. Whereas if we'd pulled the trigger a month earlier, there would have been no risk. It would have been a very simple process. So keep an eye on probation, diarise it, mark it in your calendar.
Fantastic, thank you. We might have time for one more question this morning. The final one I think we can work through is, we think our business is primed for growth and we've enticed people to work for us on that basis. Is that a problem for the Australian consumer law?
So, yeah, good question. Not really. The important bit there is, we think we're primed for growth. And if that's what we're telling people, that we think we're primed for growth, that's okay. The misleading, deceptive conduct claims in employment are really there for when an employer knowingly misleads someone and induces them to join. So if the representations you're making are true, as well as you know them, you're fine. You haven't misled anyone. It's okay that if it turns out that the growth doesn't materialize, you're not going to be sued for misleading, deceptive conduct, or certainly you might be sued, but you're not going to be liable, you're not going to lose, as long as when you made those representations, they were true. And commonly something after the fact will intervene, and that's fine. So it's okay if they don't materialise. It's only a problem if when you said them, you knew they weren't true. Now, I can see there are a bunch of other questions there, and so we're going to have to wrap up now. Basically, if you leave your details in the survey, at the end, we'll be able to help you out with any questions that we didn't answer. And we can also have a chat with you about how our membership might be able to help you. But yeah, just a reminder, obviously it's a free webinar, but we really value your feedback. So if you can take 30 seconds to fill out that survey at the end, we would be very grateful. As I said, we'll try and improve them always and make sure they're as useful as possible. But I think we've got through a lot today, and thanks for staying with us on all of that, and we hope to see you at the next one.